All right. Well, I think we'll get going here. It's 12:03. Hello, everybody. I'm Ben Hart, HART Investment Group, National Bank Financial. Excited to have Jackie Power here with us today. We're going to be discussing the role of the executor. We've settled, I think, 4 estates in the last quarter. So we've certainly gone through a number of these conversations recently. We thought it'd be worthwhile to go through and answer some of the questions that continue to come with us. Jackie is AVP of Mackenzie's tax and estate team. And so Jackie's going to tell us about the ins and outs of what it's like to be an executor, some highs, some lows probably as well. I look forward to the presentation. So if you have any questions throughout the presentation, there's a chat box in the bottom. Feel free to put them in there. I may ask and interject as we go throughout the presentation, but certainly Jackie's going to leave time for questions at the end too. But if there's something topical about a current slide, please drop a question into the chat box and I'll drop it into the conversation with Jackie. So Jackie, excited to hear what you have to say today and looking forward to the presentation. And it's over to you. Please take it away.
Great. Thank you so much, Ben. Thank you all for calling in today. I'm really happy to have the opportunity to speak with all of you with respect to the role of the executor. As we'll go through the presentation today, I think you'll find it really interesting. For many years, it was really an honor to be asked to be someone's executor. After today, if you're someone's executor, you may be asking yourself, what did I do to you? Why do you want me to take on this role? Because it is really complex and it's very different than it once was. So I'll take you through and just help you understand what's involved. So my presentation will be about 40 minutes in length. And as Ben said, that allows us to have lots of time for questions if there are any. Now, before I get into the actual role of the executor, I wanted to talk a little bit about choosing an executor, because this is something that's really important. So if you have 5 children, I highly recommend not having all 5 children as executors, because essentially everyone needs to work together. Everybody needs to sign off on everything. And it can really create a delay in getting things, just settled if there are too many people who are executors. Another thing to consider is if 2 individuals do not get along, I highly recommend not having them as co-executors. I see Ben smiling, but I was actually approached after one of these presentations, and a woman came to me and said, my sister and I are co-executors on my mom's estate. And I said, oh, that's very common. She said, oh, no. My sister and I don't get along. And my mom thought this was a great way to bring the 2 of us closer together. As you can imagine, there was nothing further from the truth. It took a ridiculous amount of time to settle that estate because the sisters just couldn't agree on anything. So when you're thinking about executors, what I would say is think about proximity. So what I mean by that is if you can find somebody in the same city or town as you, that's ideal. The same province is helpful, but the same country is a bit of a necessity. Now, it's not a legal requirement to have a Canadian as your executor. But if you have a non-resident as your executor, that individual needs to be bonded in order for them to be able to settle your estate. And that's essentially additional insurance that you need to get on that individual for them to be able to settle the estate. The larger the estate, the more expensive that bond would be. So that's why generally it makes sense to try to find someone local. Now, once you have chosen an executor, I highly recommend that you ask that individual if they are up for the role. I cannot tell you how many times I've been approached by people who found out that they were the executor at the time of that individual's passing. And as we'll see when we go through the presentation today, it's really helpful to be able to have an exchange of information between the executor and yourself prior to passing. It just makes settling the estate that much more simple. So that's why generally you would want to have that conversation beforehand. Okay, so now let's get into the presentation. First and foremost, I am not here to replace any advice that you might be receiving from lawyers, accountants, any sort of tax professionals. The idea today is just get you thinking about the role of the executor, thinking about who you've chosen, thinking about if you are an executor, what that role entails and the complexity that's involved with respect to that. So first and foremost, really important to use something when you're an executor, you have to perform your duties using something called the prudent person rule. So essentially, you're managing the affairs of the estate the way that you would manage your own affairs. And you really want to make sure that you're always acting in the best interest of the beneficiaries. You want to act honestly, you want to act judiciously. It's also important to make sure that you are avoiding conflicts of interest. You do not want to put yourself into a situation where you're now in a conflict of interest position, because that's not helpful to you, and it's certainly not helpful to the settlement of the estate. Another thing to consider is if you're generally a very aggressive investor, you don't want to invest the assets of the estate aggressively, because if those assets decrease in value and it's your fault for that, you could be personally liable for that. So you want to make sure that you're really doing what's in the best interest of the estate. Another thing that you have to consider is it does not matter what your feelings towards the beneficiaries are. You have to act impartially and objectively with all of the beneficiaries. So you really have to take that personal component out of the whole situation. So now let's get into the steps. So just for your knowledge, so you know how long approximately, I have 10 steps that I'm going to take us through. So the first step is to locate and review the will. So a lot of people feel the first step is to make the funeral arrangements, but what we're finding is more and more people are starting to put their funeral arrangements into their will. So throughout this presentation, I'm going to provide you with all sorts of different stories that I've sort of had told to me over the years, just to help you sort of center yourself around some of these things that I'm mentioning. So the first has to do with those funeral arrangements, or it being in the will. Essentially, I was approached by an individual, and he had said to me, my brother was his best friend's executor, and he had given his best friend just the most beautiful send-off. People approached him afterwards and were saying how lovely it was, and he was feeling really good about himself until he opened the will and realized the send-off he had given his friend was nothing like what the friend had wanted, and now he has to live with that. So you want to make sure that you're following the steps, just to make sure that, you know, if your friend or loved one did have any wishes that they've put in the will, that has been taken care of. Now, for many years, many of us were told to put our wills into our safe deposit boxes. That works really well if your executor has access to your safe deposit box. If they don't, then what happens is this becomes a chicken and the egg situation. So what I mean by that is, in order for the executor to be able to access the safe deposit box, they need to prove that they're the executor. But to prove that they're the executor, they need to get the will that's in the safe deposit box. So eventually they will be able to get access to it, but it really does slow down the process. So what is ideal is if your lawyer is willing to hold on to your will. More and more, I'm finding lawyers are providing the originals back to the individual. But if your lawyer is willing to hold on to it, I highly recommend that you take them up on that. Now, if you have your original will, what I would say is more people are starting to put these into fireproof boxes. So what I would suggest is put the will in the fireproof box, but do not lock the box. And the reason I'm saying don't lock it is because if your home is burglarized, the burglars will open the box, they'll see it's your will, there's nothing that they can do with that, so hopefully they'll leave it behind. But in the event that there's a fire, hopefully the will remain intact. The reason why it's so important to keep that will safe is because the executor needs to work off the original will. And that's why it's so important to make sure that, that you know exactly where that original is. Now, if your executor cannot find your will, or if you do not have a will, in that situation, you're considered to die intestate, and you lose control over how your estate is distributed. So essentially what happens there is if you have a spouse and 2 or more children, this is how the estate would be distributed. So the spouse would get the first $350,000 of the estate, and then the children would get 2/3 of what's remaining, and then the husband, the spouse, the final 1/3 of that estate. If the children are minors, the spouse has no say whatsoever in how the children's assets are managed. And once the children turn 18, they would gain full access to their inheritance. And in my experience, generally, an 18-year-old is not in a position to inherit a large sum of money. So generally, you would want to make sure that you have a will so that you're protecting those children from themselves. Now, Ben?
Yeah, just so what percentage of Canadians have wills in place versus don't in place? What's that like?
Less than 50%. So
Wow.
I had thought previously it was 50%. I did a presentation a couple of weeks ago with an estate lawyer, and she said only 40% of Canadians currently have wills. So this is something that applies to a lot of individuals, and something that is really important to make sure that you don't fall into that category. You want to make sure that you have a will so that you're the one who determines how that estate is distributed. Where I find intestacy to really fall short in Ontario in particular is with respect to common law spouses. So a common law spouse in Ontario is equivalent to a married spouse in pretty much every area, but not intestacy. So they are not recognized as a spouse for this preferential share or for the remaining 1/3. So if you're in a common law relationship or you know someone who is, it's even more important in that situation to make sure that you have a will so that you can ensure that your spouse is taken care of. Now, the next step is to make the funeral arrangements. So if you have prepaid or pre-planned your wedding, your funeral, if you have any wishes as far as your funeral is concerned, please make sure that you communicate that to your loved ones. Because in my experience, when someone passes away, people don't act rationally. If there's any chance that people will fight, they will. And we came across that. So I used to work with an estate lawyer. So essentially, he was based out of our Vancouver office. Before he started working at Mackenzie, he had his own practice. And one of the last clients that he had was an elderly gentleman who had 2 sons. Now, he knew there were going to be problems with the brothers when he passed away, so he made sure the brothers understood exactly why he had distributed his estate the way that he had. One thing he didn't think about were funeral arrangements. So one of the brothers wanted a very lavish send-off for the dad. The other one wanted a no-frills funeral. Well, that was enough to get the brothers fighting. In the end, it was the brother who wanted the no-frills funeral who won out. But this destroyed the relationship between the 2 brothers. The last time our estate lawyer had spoken with one of the brothers, it was more than 2 years after the dad had passed away, and the brothers still weren't speaking. So the more communication you can have through the process, the more people understand what your wishes are, the smoother this whole process will be. Now, one thing that's really important to be aware of, if you are the executor, it is not your responsibility to personally come up with the money to pay for the funeral. This is an expense of the estate. Now, a lot of the times when someone passes away, all of the accounts are going to be frozen as the estate is being settled. In that case, in my experience, what has happened is if you go to the bank and explain to the bank that the reason why you want to pull this money out is to pay for funeral arrangements, most of the time they are going to allow you to do that. So I haven't come across a situation where they have not allowed that because they realize that this is a very large expense and something that should be covered by the estate. Yes.
Yeah, just a comment on that. Certainly from our side as well, when people need to withdraw funds from an estate account, either with us or the accounts for their parents or grandparents, we just need a letter of direction, and then we can send a check to pay for those expenses.
That's so helpful. Thank you.
Yeah. Mm-hmm.
Now, the next step is to solicit professional counsel. So this is essentially allowing your executor to engage an accountant, engage a lawyer, because there are some situations, especially if we're looking at probate and that sort of thing, where you might want to engage one of those individuals. So if you have a clause in your will that indicates that you are allowing your executor to solicit professional counsel, then this can be an expense of the estate, and there's no problem with that whatsoever. If you do not have that clause in your will, your executor is still able to go and engage those professionals, but we have seen situations where the beneficiaries have contested that because essentially that's money that is being used to pay these professionals. that's less money that the individual will have as far as an inheritance is concerned. So this is not something that I'm seeing on a regular basis, but again, all of my stories today are sort of worst case scenario, so that you can be aware of some of the issues that can arise as you go through this process.
So just before you jump onto that,
Yeah,
Jackie, sorry, just on in regards to when you solicit a professional, is there a minimum and a maximum that can be charged? Is there like a rule of thumb around how it works? What's that like?
Yeah, so as far as these professionals are concerned, there isn't a stipulated minimum or maximum. As far as executor fees are concerned, there is. And I will go into those in greater detail a little further in the presentation. But as far as the lawyers and accountants, it would be whatever is sort of reasonable. So if you're going to a regular accountant and just having them do, maybe probate, then I assume that they would charge by the hour, whatever their hourly fee happens to be.
Yeah. Okay. Yeah, perfect. Thanks.
The next step now is to notify the beneficiaries. So generally what we recommend is that you have a meeting with all of the beneficiaries at the same time so that everybody is hearing the same message. And it's really important for people to understand how long you think it's going to take to settle the estate. So some individuals feel as soon as someone passes away that they're going to receive their inheritance right away. And that's just simply not the case. A very simple estate can take 1 to 3 years to settle. If it's more complex, it can take 5 or more years to settle. So it's really important for the beneficiaries to understand approximately how long you think it's going to take, so that they're not calling you every week or every 2 weeks wanting to know where you're at. Now, they still will call you. There's no question. They're going to want to know where you're at. But hopefully, instead of calling on a weekly basis, maybe it'll be on a monthly basis or something like that. And hopefully it won't be too disruptive. Now, when we're looking at beneficiaries, this is your plan. It is completely up to you as to who you want your beneficiaries to be. So generally what we see would be spouse, children, grandchildren, nieces, nephews, that sort of thing. But if you have a good friend up the street, or a neighbor who's really close to you that you want to have benefit from your estate, this is your plan. And you can have whomever you choose as beneficiaries of your estate. We also find charities are frequently beneficiaries as well. That not only allows you to be able to support these charities, but it's also really beneficial from a tax perspective as well. It's a great way to reduce the taxes that would apply at the time of your passing. So it can be a real win-win in that situation. Now, this step is going to be the largest step, I would say. This is the one that's going to take the most of your time. So it's essentially your responsibility as the executor to notify the government that the individual has passed away. If the person is still working, you would notify the employer. Sometimes funeral directors will notify the government, so you may not have to do that, but that's something to discuss with them for sure. It's also your responsibility to redirect the mail. It's your responsibility to cancel any subscriptions they may have. It would be your responsibility to make sure that if the property happens to be vacant, it's your responsibility to make sure that you are notifying the insurance company that that property is vacant. This is a really important step and one that you don't want to miss. I was approached after one of these presentations and they missed that step. And essentially what happened was there was a flood in the home. It did $100,000 worth of damage. The insurance company wouldn't cover it because they hadn't been notified. So then the executor was personally liable for that. Ben, is there a question?
No, just you made just a brief comment there on the funeral director sometimes will notify the government. And how would they do that? What's that for specifically?
So that would be if somebody's receiving CPP, OAS, that sort of thing. And then just generally the government needs to know that the individual has passed. So that would also be included when the executor does the terminal tax return. They would notify CRA that the person had passed at that point. But so yeah, for the funeral director, it would be predominantly for CPP and OAS. Yeah.
Perfect. Thank you.
my pleasure. Another thing to consider as well is if you feel there's a chance that someone will come into the property and start taking assets out of the property, it's your responsibility to change the locks on the property. So I talked about the two sisters who didn't get along at the beginning of the presentation. So one of those sisters knew that there were going to be issues when the mom passed away. So the mom passed on Thursday. So she contacted the property management company on Friday and said, I need to get the locks changed on my mom's property. And they said, of course, no problem whatsoever. But because it's the weekend, we can't get anybody in until Monday. So Monday, she and the property management company walked in and she looked around, and it was obvious to her that anything of value had been removed from the home. But the issue was that she hadn't gotten in to do an inventory of the property. So it was a she said situation between her and her sister, and there was no way for her to prove that her sister had taken this out. So again, these are all worst case scenarios, but just things that I want you to consider. Another thing that you have to think about is, what do you want to have done with your online presence? So if you have a Facebook account, LinkedIn, Instagram, Twitter, any of those, what would you like to have done with those after you pass away? And make sure that your executor is aware of that. If you want all of those accounts to be shut down, then essentially what you would do is provide your executor with the various passwords so they would be able to shut those down. Now, you wouldn't provide them with the passwords until after your passing. What a lot of individuals will do is put a file folder together of information they want to communicate to the executor after their passing, so that is something that's available to the executor at the time that you pass away. Now, when you're trying to figure out, where assets are, first and foremost, what I always recommend is that you introduce your executor to your financial advisor, introduce them to Ben, because Ben has relationships with all of the financial institutions that currently hold your assets. So he's actually a huge asset to your executor, because he can get the ball rolling and start the process as far as helping to get started as far as the settlement of the estate is concerned. Now, if you have no idea where assets might be, a great starting point would be the prior year's tax return, because from there you can see, was the deceased receiving employment income? Were they receiving CPP? Were they receiving OAS? Where were the investments held, that sort of thing. So it can be really quite beneficial to start with that as far as a great starting point, because there is going to be a lot of work involved in transferring those assets out of the various financial institutions and into an estate account where you can start settling the estate. Now, the next step is to submit for probate. So this is another large one. As I said earlier in the presentation, this might be somewhere where you might want to engage an accountant to help you through the process. So essentially, probate is going to be based on any assets that flow through the deceased estate. So if someone had non-registered assets, whether those are invested in stocks, bonds, mutual funds, ETFs, those are all going to form part of the estate, and those will be subject to probate. If the deceased was the last person on title on a property, that's also going to form part of their estate. Any jewelry, automobiles, coin collections, art collections, antiques, all of that also forms part of the estate. Any registered accounts or life insurance policies that either don't have beneficiary designations or have the estate as the beneficiary, those will also form part of the estate, and those will also be subject to probate. So let's look at the flip side. What is excluded? If there's a mortgage on the property, the value of the mortgage is going to be subtracted from the fair market value of the property before that probate calculation is done. If those registered assets, life insurance policies have beneficiary designations, those will pay directly to the beneficiaries. They won't form part of the estate, and as a result will not be subject to probate. And then finally, if there are accounts that are joint with right of survivorship where beneficial ownership has changed, that will also not be subject to probate. Now, oh, sorry.
Yeah, no, just on the joint accounts, I think maybe you're going to elaborate on that. but please go ahead. I do have a
Okay.
question on that, but go ahead.
Awesome. For it to be joint with right of survivorship or beneficial ownership has changed. Essentially, the way it works is that if you have an investment account, you add an adult child on as joint owner on that investment account. In order to avoid probate, at the time that that adult child is added on, you need to deem dispose half of the account. So you're essentially considered to sell half of the account, and you pay capital gains tax on that. So now you own half of the account and that adult child owns half of the account. So from a probate perspective, you've accomplished what you wanted to accomplish. They would inherit that account. It would not be subject to probate. Your half of the account is still subject to capital gains tax, but at least you've avoided probate. Now, there are three issues as far as this is concerned. First is that adult child now owns half of the account. So if you want to make any changes on that account, you need that adult child to sign off on those changes. Second issue is if that adult child has creditors, their creditors can seize their half of the account because they are the beneficial owner on half of that account. Third issue, if that adult child goes through a marriage breakdown, their half of the account is considered family property when that equalization calculation is being done. So really important when you're making decisions, don't just try to avoid probate. You want to make sure you're making the right decisions for you because it could adversely affect you otherwise.
So I'll just add a kind of maybe a caveat and question to that is there, because I've done this on and off for clients as well and tried to record it properly, should you be noting it somehow with CRA so that when the older client passes away, you don't get into this? Is there something you should do with CRA?
Yeah, so at the time that that adult child is put on and they deem dispose half of the account, you need to put that onto the Schedule 3 with CRA. And that way CRA can see that the tax has been paid on half of the account. And that way the executor does not have to pay tax on the full account. And if CRA ever comes to them, they can very clearly show that the half of the capital gains tax has already been paid. Yeah, that's a great question.
Great.
So what is what's the fee? If the account is less than $50,000, there's no probate that would apply in that situation. Anything above $50,000, it's 1.5% that's charged in probate. So if we're looking at a $2 million estate, we're looking at $29,250 in probate. So is it something we would prefer not to pay? Of course, nobody wants to pay any extra fees, but in the whole scheme of things, it's not astronomical. And that's why I was saying, like, you could easily cost yourself more by trying to avoid probate than what that actual probate fee would be. Now, prior to, yes.
Yeah, sorry. And I just want to add maybe a point of clarification there. When you say that, I think ultimately probate absolves the executor of any future responsibilities of the estate is effectively what you're saying, right?
Yeah, so yes and no. Like it's so the province, as we'll see shortly, can still come back and like audit the estate, and if they feel there's issues, then they can still fine them for that and that sort of thing. But the idea is that this is essentially, probate is giving the executor the authority to be able to settle the estate. It's essentially the province rubber stamping the estate, saying, okay, I feel that Joe Smith is the executor and they're the ones who are going to settle the estate. And then it gives them the power essentially to be able to go forward and settle that estate.
Okay, great. Thanks.
Now, prior to 2015, it was really simple to probate an estate. Essentially, an application would be made to the Superior Court of Justice in Ontario. The executor indicated what the value of the estate as a whole was, and then they signed an affidavit to that effect. There were no valuations, no appraisals, no supporting document whatsoever that was required. And as a result, what the government found was that a lot of executors were underestimating what the value of that estate was. So they decided to turn this into a much more regimented process, and that's exactly what they did January 1st of 2015. So first thing that they changed is they transferred the administration from the Attorney General to the Ministry of Finance, because they felt the Ministry of Finance would be more likely to be able to collect those probate dollars. Next thing that they did is that they now require that an estate information return be completed within 180 days of receiving that probate certificate. And essentially, the estate information return would include information on all of the assets that flowed through the estate. If the executor failed to provide information about certain assets, if they provide fraudulent or misleading information, they could be charged up to 2 times what the probate tax payable would have been. And in severe situations, the government has the ability to imprison the executor. Now, rest assured, I've heard of no situations in the past 8 years, or 8.5 at this point, where an executor has been imprisoned, but if the government feels it's warranted, they have the ability to do that. And then the idea about having all this information is it's going to make it a lot easier for the province to audit that estate.
Just a question then, EIR, is that a form, like is there something formal that you complete and send? Okay.
Exactly. Questions about all the different assets that flow through the estate. Yeah.
Perfect.
A question I get a ton is whether probate's always required. So if the estate is less than $50,000, probate would not be required in that situation. But generally, I would say probate is going to be required. Now, different financial institutions have different thresholds as to where they require probate. But the thing is, if one financial institution asks for probate, then the entire estate ends up needing to be probated. So I would say 9 times out of 10, probate is going to apply. Now, the next step is to advertise for creditors. This is an area where people frequently say to me, I knew the deceased really, really well. I know they didn't have any creditors. I don't feel I need to follow this step. What I say to that is we think we know people really well, but we don't truly know people. You don't want to be in a situation where you haven't advertised for creditors and creditors come forward after you've paid out the residue of the estate. Because if that happens, then again, you are personally liable for that debt, and you would have to pay that yourself. So you don't want to put yourself into that sort of a situation. So as far as the rules, essentially you need to make an advertisement in the local newspaper for 3 consecutive weeks. And the creditor needs to come forward within a month from when that first advertisement was made. And as long as you follow this, then you've done your due diligence and you won't have any issues. Now, the next step is to pay debts and complete final tax returns. So with this, any sort of outstanding debt that an individual has, you need to pay off, whether it's line of credit, credit card debt, mortgage, pay-as-you-go furniture or anything, maybe a car loan, all of that needs to be paid off. Now, if there isn't enough cash within the estate to pay all of the debts, it is your responsibility as the executor to start selling assets within the estate. If there aren't enough assets within the estate to pay all of the debts, it is not your responsibility to personally come up with the money for that. In that situation, what would happen would be the estate would be considered to be bankrupt, and then you would go through the process as far as filing for bankruptcy. Now, one creditor that you definitely don't want to forget about is CRA, because they will not forget about you. CRA will always want to get their tax dollars. So you want to make sure that you get a clearance certificate from CRA before you start paying out the estate. So essentially with CRA, there's generally 3 tax returns that you would do. So there's the terminal return. So the day before we pass away, we're considered to have sold all of our assets. So all of that would go on to the terminal return. If you have a spouse, your spouse is able to inherit your assets on a tax deferred basis. So in that case, it would be when the second spouse passes that tax liability would happen. Now, sometimes when someone passes away, there are certain payments that are due to them that they haven't actually received. Maybe there's an OAS payment that's about to go in, but it hasn't gone into their bank account as of yet. That would go onto the needs and things return. And then the other return would be the estate return. So that would be anything that's taxable within the estate. So essentially, you would need to do all of those various tax returns, get the clearance certificate from CRA, and then at that point, you're set. And then once that's done, this is where you're able to start to distribute that inheritance. So the way that it works is that first, any cash legacies or specific property bequests are paid out. Then trusts are paid out. And I'm just going to go on a little tangent about trusts because I find these are an excellent estate planning tool. So I just wanted to mention a few ways that you could use it. So for me, I have 2 minor children. In the event that I pass away, I have discretionary trusts that are set up for my children. My brother is the trustee on those discretionary trusts. So because it's a discretionary trust, he's able to pull money out for the kids as he sees fit. And then I have parameters on that trust that say the kids are able to get X, like a third of the trust at 25, another third at 30, and then the balance at 35. And this is just a way that I'm essentially protecting my kids from themselves. It's allowing them to get some of their inheritance, but not be able to blow all of that money all at once. My daughter's very responsible with money. My son, not so much. So it just allows us to protect them from themselves. Now, you may say, I don't have any minors that are part of my plan. In that situation, the trust may still be beneficial. If you have a young adult that is benefiting from your estate, or somebody who's a spendthrift, or someone who has addiction issues, trust can be really beneficial to them as well.
So you mentioned the trust. I think that makes a lot of sense. So is this end up being a second document, or just written within the will? It's a trust is set up, or how does that work?
Yeah, great question. It's written right within the will. So, and then the will is used as the trust document. So that would go to the financial institution, and that's what would be used. And right in the will, it has all of these parameters as to how it's set up. So yeah, you would just need the application, that will, and then you're able to set up the trust. So very straightforward. And it's nice because it's different than a trust that's set up during your lifetime. With that, it has to go to a lawyer. You have to have a trust document created. But when it's a testamentary trust, since it's already included in the will, you're able to use the will as that trust document.
Oh, okay, perfect. We did have, sorry, I done the slide, or are you going through? We did have a question come in, so I just wanted to shoot it out there, if that's okay. Yeah. So we had a question that said, am I correct to assume that the probate costs and issues only arise when there's no will?
No, so probate, you have to go through probate whether you have a will or not. If you do not have a will, then through part of the probate process, somebody would essentially step forward, say that they want to be the executor of that estate, and then they would go through the probate process in that situation. But even if you have a will, then it still needs to be probated, because in that situation, it's giving the executor the authority to be able to settle the will.
Great, thank you. Sorry to interrupt there.
My pleasure. No, not at all. So yeah, so once the trusts have been paid out, then the residue of the estate is paid out to the remaining beneficiaries at that point. And finally, just talking about keeping accurate records, it is extremely important for you to keep track of everything that you're doing within the estate, because at some point the beneficiaries are going to come to you and want to know where you're at as far as settling the estate is concerned. So you want to be able to show them what you've accomplished so far and what you're still working on. Another thing to consider as well is if you want to be reimbursed for any of your expenses, you have to be able to provide receipts of those expenses. And another thing to keep in mind as well is that the province can come back and audit the estate for 4 years if they feel there are no issues with the estate whatsoever. If they feel there was fraudulent or misleading information, they can come back and audit the estate indefinitely. So really important to make sure that you're holding on to those records. From a CRA perspective, they ask that you hold on to the records for 6 years. They say that they'll audit the estate for 3, but that they want you to hold on to them for 6. So it's, yeah, you go from there. Now, there are a couple of things that I wanted to just pull out that I think are really important and just really want to hit home. So important to make sure your executor knows where your will is. As I said, if they do not know where your will is, they cannot locate it, then you're considered to die intestate. So you don't want to put yourself into that sort of a situation. Another thing to consider that I didn't mention when I was talking about securing estate assets, the family pet falls under this as well. So if you do have a family pet, you want to think about who you want to have take over that animal in the event that something happens to you, because for many of us, that family pet really is a member of the family. And if the executor doesn't know where to take that animal, it's their responsibility to try to find someone who's willing to take it on. But if they can't find anyone, essentially it's their responsibility to take that animal to the Humane Society. And I know with a lot of us, these animals really are very special to all of us. And the idea of having that animal at the Humane Society is pretty heartbreaking. With respect to advertising for creditors, I get a ton of questions about, because we're so online these days, is there a way to advertise for creditors online? And I am happy to say there is. So there was a court case that happened in Ontario in December of 2016, where the government said, yes, you can now advertise for creditors online. So there is a site that is called Notice Connect. And as long as you advertise through Notice Connect, then you've done your due diligence, and you're able to go forward from there. With respect to final tax returns, one thing I did want to mention with our close proximity to the US, I thought it was worth mentioning that the US is different than other countries in the world. So the US tax is based on citizenship rather than based on residency. So if the deceased was a US citizen and they were a Canadian resident, then what happens is that tax returns need to be done in both Canada as well as the US. So in that situation, it's even more important to make sure that the executor can solicit professional counsel, because you want them to be able to speak with a cross-border specialist who knows both sides of the border, so that it ensures that the deceased tax returns got any eligible credits and deductions on both sides of the border. Now, finally, keeping accurate records. Another reason this is so important is for executor compensation. So Ben had asked about executor compensation earlier in the presentation, and essentially the maximum that you can charge as an executor is 5%. So 2.5% on the assets that flow into the estate, and then 2.5% on the assets that flow out of the estate. I highly recommend, if you want to allow your executor to charge executor compensation, that you indicate an amount within your will, because time and time again, wills are contested because of, or like estates are contested because of executor compensation. The beneficiaries do not want the executor to be receiving compensation. Now, some estates are very complex and take up a lot of time for the executor, so they should be compensated in that kind of a situation. So if you know that you have a complex estate, I highly recommend that you include a clause within your will for executor compensation. I look at my mom. My mom has 2 children, my brother and I'm her executor. I'm not charging executor compensation because her estate is very straightforward. Most of her assets have all been, amalgamated to one particular, broker. So it's nice and easy for me to settle everything at this point. And that would just be taking money away from my brother. So there was no point for me to charge executor compensation. But as I said, it's a very simple estate. If this was an estate where it was going to take me hours, and this is frequent, that it's, hundreds of hours, then you do want your executor to be compensated for something like that. And I just wanted to finish it up by talking about our executor checklist. So Mackenzie has a checklist that we've developed. I've actually updated it from this picture. I've now put it into the different steps to make it really straightforward for everyone to follow. And there's a checklist. So as you go through all of the various steps, you're able to check those off and ensure that you're not missing anything. And that's what I wanted to cover today. Now, I know that I've thrown a lot at you in a really short period of time. So if there are additional questions, I would be delighted to take those.
Yeah, perfect. That's great. Thanks, Jackie. That was awesome. Covered a lot of great things there. I had a few questions come in, a few of my own, but so I'll ask the first one that came in. It said, are there any issues if an executor is from out of province? For example, lives in Ontario, but the estate's in Quebec. How would that be handled?
Yeah, so it can. Some provinces require that an individual be bonded if they're in a different province. But a lot of the time, the deceased within their will can waive that bond when it's within the same country. So it happens frequently. So for instance, my mom lives in BC, I'm in Ontario, and I'm her executor. And this is quite common just with Canadians moving all over the place. Where the biggest concern, as I mentioned, is if it's a non-resident of Canada, that's
Right.
where the issues can be more complex.
So just on top of that, hypothetically, say you have someone who passes away and has assets in Ontario and assets in Quebec and passes away in Ontario, how does that estate get dealt with?
Great question. If there are assets in Quebec as well as Ontario, I highly recommend that they have two wills. So one for the Quebec assets, one for Ontario, because Quebec is civil code and Ontario is common law. So we can slow down the process. Also, the estate, if they passed away in Ontario, the estate would have to be settled, and it's an Ontario will. It would have to be settled in Ontario first, and then the will is taken to Quebec to settle it in Quebec. So that slows down the process. It also makes it more expensive because in Quebec, they have notarial wills. So the wills are drawn up by a notary, and then they get registered with the province. So probate doesn't apply to those wills. If you're using an Ontario will to settle assets in Quebec, probate does apply in that situation. And where we see that quite frequently is cottages or cabins in Quebec. I grew up in Ottawa, my cottage was in Quebec, and that was something that we had to plan for because it's something that is very, very common in the Ottawa area, but something that's really important. And a lot of people don't realize that, the benefits of having those two wills when you're looking at something like that.
Just before we drop that one and go on to the next question, a bonding, is it a percentage of the estate that the bond cost is associated with?
It would be, yeah.
Okay.
And that I don't know exactly what that
Sure.
cost would be, unfortunately, but yes, it would be a percentage of the estate.
Yeah. Had another client ask if we're able to share this presentation with them. That's fine?
Definitely.
Okay, perfect. Next question was, in a joint portfolio with a spouse who passes, is half the portfolio subject to probate?
It is not. When it's with a spouse and it's joint with right of survivorship, the spouse would inherit that without probate applying. When the second spouse passes, that's when the probate would apply.
So that'll be province specific as well, I guess.
Correct.
Yeah. Okay, perfect. I had certainly lots of things, but one of the questions that we often get, is there any gifting rules in Canada? Can I give people money? What's that like?
Yeah, that's a fantastic question. Very happy to say we don't have gift tax in Canada. They do in the US, but thankfully that's not something we have here. Now you can't gift to minors. That's something to keep in mind because a minor can't have assets. So you would have to set up a trust for a minor. But if you had a child who is age a majority or a grandchild, you can gift money to them. There's no maximum and no tax that would apply there.
So just further on that, is there any things that you've seen where hypothetically in the last month of the person's life, they gift 90% of their assets to somebody? Does that end up getting challenged in court or no?
So it all depends. And that's
Right.
something with tax.
Sure.
It all depends.
Yeah.
So if it seems as though, so if there's one child is the beneficiary, that child is gifted stuff, the parents are terminal and that they've gifted it, that's not going to create a problem. If it's like a situation with my brother and I, and my mom gifted 90% of her assets to him, I would challenge that.
Yes. Makes sense. The next question came in. If someone has assets in another country, like the UK, for example, would you be required to seek legal counsel in that country, as well as someone locally here?
Yeah, they should. You in that situation, you would likely want to have two wills, a will for the assets in the UK and then your Canadian will. If you're a Canadian resident at the time, all assets will be on your Canadian tax return because it looks at your worldwide assets. And any applicable tax would apply here. But then generally there would be foreign tax credits that could go onto the UK to avoid any sort of double taxation because we do have tax treaties with the UK.
Another thing that triggers in my mind with that is just about corporations or a business. If you have a small business or something, should you have separate wills? Should it be combined? How would you do that?
Yeah, 100%. You should have separate wills.
Okay.
And the reason for that, and we're super fortunate in Ontario that we can do two wills. There's only us in BC that allow two wills. So definitely take advantage of it. And the reason why it's so great is because if you have your corporate assets on your personal will, those are going to be subject to probate. Whereas if your corporate assets are in their own standalone will, that will would not be subject to probate. It would only be your personal will that would be subject to probate. So that can be substantial savings depending on the size of the corporation.
Okay, awesome. Let's see, we'll have one final call for questions here. But as we start to wrap up here, the biggest thing that I got out of this is that communication with the executors and maybe even your beneficiaries is one of the most important things to make the process smooth and simple. And so Jackie had mentioned you have, I think this was the estate executor checklist that you've created. That's an excellent source, certainly for the individuals with the will, but also for the executors in preparation. Is there anything today that we didn't cover or that I didn't ask you that you think is pertinent when people are thinking about who their executor might be?
Yeah, I mean, I think we covered most of it. One thing I did say in the presentation, but I'm going to stress it again. Once you've chosen somebody, please ask that person if they're up for the role, because it is a lot of work and they might not have the skills or they might be too busy, right? And you do put alternates into your will, so you could have another person who would step in. But it's just always better to make sure that they understand that this is what you would like to do, and it just makes it so much smoother if there's communication between the two prior to the deceased passing.
Sorry, another one popped up in my mind. They keep coming as you're talking here. But so if you are named executor and something happens in your life that you can't manage it anymore, is there a process to relieve yourself of the duties?
Most definitely. Yeah. If it happens prior to if the person passes away and somebody comes to you and says, okay, you're the executor, you can say, I'm sorry, like I agreed to it previously, but I'm just not at a stage where I can do that right now. And then there's an alternate. So then the alternate is the one who would step in. If there isn't an alternate, you can still say that you do not want to do it. And then it would just be a matter of trying to find somebody else who is willing to settle the estate. And generally it would be somebody who's a beneficiary of the estate.
So, and this will be my last one, I promise. What happens when you do get executors that aren't cooperating? What is the course of action, if anything?
Yeah, I mean, sometimes it's in worst case scenarios, I've seen it go to court, right? Like it can be terrible. And in that situation, nobody wins because the court fees end up being so expensive, right? So that's why it's important to try to get people, if you are having more than one, try to get people who get along, because it can just really slow down the whole process and make it just not good at all.
Yeah, for sure. Listen, I think that was fantastic. I really appreciate you taking the time. Great presentation. Hopefully everyone learned a lot today. I certainly did. I appreciate you taking the time to come and speak with us today. And thanks very much, Jackie.
Thank you so much for the opportunity.
I hope everyone has a great day, and we'll talk to everyone again soon. Thanks.
Great.
Take care.
Thanks, everyone. Bye-bye.